Hello and welcome to Triage, rapid legal lessons for busy healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
As many of our listeners will know, the Department of Health and Human Services Office of the National Coordinator for Health Information Technology, or ONC, issued its final rule regarding interoperability and information blocking earlier this year. The rule is extensive and includes several compliance deadlines, which health IT developers, health information exchanges, and healthcare providers should be aware. I'm Maggie Power, and I'm here with my colleagues Gina Bertolini and Lindsey Rogers-Seitz, and we're attorneys in K&L Gates' National Healthcare Practice Group. Our healthcare practice group tracks the evolution of healthcare regulations, including those related to digital health. This week, we published a client alert that provides a broad overview of ONC's much anticipated final rule on interoperability, information blocking, and the ONC Health IT Certification Program. Given the breadth and impact of ONC's final rule, we will publish additional client alerts, and this podcast will be the first in a series of podcasts related to information blocking and health IT certification. This podcast will specifically address an exception to the information blocking rule that will heavily impact our healthcare provider clients, the preventing harm exception. Before we introduce the preventing harm exception, we will provide a bit of additional background regarding ONC's interoperability final rule. Gina, can you provide some background and context for us?
Sure. Thank you for that introduction, Maggie. ONC is at the forefront of our nation's health IT efforts, and it's a resource to the entire healthcare system to support the adoption of health information technology. ONC is the principal federal entity that's charged with coordinating the nationwide effort to implement and use the most advanced health information technology and to promote an electronic exchange of health information so that we can improve healthcare and promote better access to healthcare. In 2015, ONC provided a report to Congress about what it called information blocking, which were actions taken by certain actors within the healthcare system that prevent or delay access to electronic health information. In that report, ONC provided an analysis of how often information blocking was happening, which in its opinion was prevalent, and recommendations for Congress that would address the incidence of information blocking. And so this is all going toward furthering complete interoperability of electronic health information. The report, by the way, for anyone who's interested, it's interesting background reading. And if you just plug in regular, search terms in a internet search engine, you can find it. And if you're interested in the subject, it does sort of lay the groundwork for what this final rule is all about. So in 2016, Congress passed the 21st Century Cures Act, and among other things, the Cures Act included a definition of information blocking and provisions to address it and to prevent it. Title IV of the Cures Act essentially did two things. One, it requires providing patient access to EHI in a form convenient for the patient, and that includes prohibiting information blocking. And two, it requires improving the electronic accessibility of a patient's EHI. As part of these initiatives, the Cures Act explicitly prohibits information blocking. So ONC is responsible for the implementation of these provisions of the Cures Act. And ONC's final report, essentially, in order to implement the Cures Act's prohibition on information blocking, as well as the promotion of enhanced interoperability, it adopts standards and certification criteria for health IT developers, and it implements information blocking policies that support patient electronic access to their EHI at no cost. The proposed rule was released by ONC in March of 2019, and after receiving over 2,000 comments, ONC released its final rule in March of this year. The final rule was published in the Federal Register on May 1st, 2020, and it's codified in the Code of Federal Regulations at 45 CFR Parts 170 and 171.
Thank you, Gina, for that background. To be clear, today we're focusing on a narrow slice of the final rule. We're focusing on the information blocking provisions, which are codified at 45 CFR Part 171. And then further drilling down on the information blocking provisions, this podcast will address one of the 8 exceptions to the information blocking and preventing harm exception. To do that, we should provide a high-level overview of information blocking, as well as a description of the preventing harm exception. Lindsey, can you help us understand what the information blocking provisions generally require?
Sure, Maggie. The Information Blocking Rule governs three categories of actors: healthcare providers, health IT developers, and health information exchanges and health information networks, collectively referred to as HIEs and HINs. The Information Blocking Rule refers to these parties as actors. Actors are considered to be information blocking if they are engaged in a practice that is likely to interfere with the access, exchange, or use of EHI, and if they knew or if they are a HIT developer or HIE, HIN should have known that the practice was likely to interfere with access, use, or exchange of EHI. Interfere with means to prevent, materially discourage, or otherwise inhibit. ONC makes clear that a determination of whether a particular practice is information blocking in each case is based on a facts and circumstances analysis.
That's right. Thanks, Lindsey. And this is Gina, by the way. We provide additional background and definitions in our client alert, but just for the sake of laying the groundwork for this discussion, there's a bit of additional context we would like to provide. ONC stated in the final rule, and the regulations, of course, capture this, that practices that are either required by law or that are covered by one of the 8 exceptions created by ONC are not considered information blocking. Practices required by law would include, just as an example, federal regulations that impose heightened restrictions on the disclosure of substance use disorder records, known as 42 CFR Part 2, commonly referred to as Part 2. Adopting practices that otherwise interfere with the access, use, or exchange of EHI, but that are compliant with Part 2 would not be considered information blocking. So that's an example of a required by law carve out from what would otherwise be considered information blocking. Additionally, ONC developed 8 exceptions, each of which recognizes important objectives that warrant practices that might otherwise be considered information blocking. Some of the exceptions include the preventing harm exception, which we'll further discuss, the privacy exception, and the security exception. Those are 2 separate exceptions, and they protect individuals' privacy and security of EHI, respectively. And the infeasibility exception, which recognizes that it may be technically infeasible for a healthcare provider or other actor to fulfill a request for EHI. So those are just 4 examples of exceptions. There are 4 others, and our client alert briefly gets into those 4 exceptions. Also important to note, to meet any exception under the information blocking rule, the actor has to meet all applicable requirements and conditions of the exception at all relevant times. And for many of the exceptions, there are many conditions. So it will be important for actors to understand the outline and the parameters of those exceptions.
Okay, so not all practices that interfere with access, use, or exchange are considered information blocking, depending on whether the practice is required by law or covered by one of the 8 exceptions. Are those the only times a practice that otherwise interferes with access, use, or exchange of EHI would not be considered information blocking?
No, not necessarily. That's a great question. ONC says in the final rule that practices that are not required by law and do not otherwise meet an exception, but that otherwise do interfere with access, use, or exchange of EHI may not necessarily be considered information blocking, depending on the facts and circumstances. Each case will turn on its own unique facts, and the practice would be evaluated on a case-by-case basis. We provide additional detail about ONC's guidance on this case-by-case analysis in our client alert, so I would ask our listeners to please refer to that for additional background and information on the exceptions and their application, as well as this sort of gray area where ONC will look at intent and facts and circumstances.
Okay, thank you, Gina. Let's now focus on the preventing harm exception. As you have indicated, ONC created the preventing harm exception for certain practices that otherwise interfere with access, use, or exchange of EHI that would not be considered information blocking. Lindsey, can you provide an explanation of the preventing harm exception?
Sure, Maggie. The preventing harm exception is probably one of the most complicated exceptions, but we will break it down into its simplest points. We would encourage anyone with questions to feel free to reach out to any one of us. At its core, the preventing harm exception requires a reasonable belief that a practice that interferes with access, use, or exchange of EHI will substantially reduce a risk of harm to the patient or another person. The risk of harm must be determined on a case-by-case basis. It cannot be based on broad classifications of certain types of records, and the practice must be no broader than is necessary to substantially reduce the risk of harm that the practice is intended to address. If the practice affects an individual's access to his or her own records, the type of harm must be a risk of harm to the life or physical safety of the patient. If the practice affects a personal representative's access to the patient's records, or if the records refer to another person in the records and affects either our personal representatives or the patient's access, the type of harm is substantial injury to either the patient or the other person referenced in the records. The harm must be determined on an individualized basis in the exercise of professional judgment by a licensed healthcare professional who has a current or prior clinical patient relationship with the patient whose EHI is affected, or the harm must arise from data that is known or reasonably suspected to be misidentified or mismatched, corrupt due to technical failure, or erroneous for another reason. There are a few additional requirements, such as that the individual must have a right to appeal information blocking of the patient's record, and generally the clinician's decision should be based on an organizational policy addressing this exception.
Based on our discussions, I understand that a full analysis of the preventing harm exception could fill an hour or more. Rather than talk about this exception in a vacuum, we would like to help listeners understand the preventing harm exception through a series of frequently asked questions and other real-world examples, so this podcast will be a first in a series. To begin to demonstrate the applicability and limitations of the preventing harm exception, we will discuss a question we have received from several clients, and that is, does the preventing harm exception cover categorical delays of lab and other test results?
Great. Thanks for queuing that up, Maggie. As you hinted, we've received this question from many of our clients. So just a little bit of background. Many healthcare providers delay the release of test results, for example, lab or pathology, in an attempt to protect patients from either misinterpreting the results or from learning about potentially life-altering results without the guidance and perspective of their practitioner. This is a very common approach among healthcare providers, and one that they really implemented over the past decade or so when a federal law known as high-tech and CMS's meaningful use, now promoting interoperability requirements, mandated the release of lab test results directly to patients. Previously, that had not been the case. Under the information blocking rule, information required to be accessible to the patient should be available without delay. In commentary related to what is considered timely access to EHI, ONC commented that it has not established a time frame, given the tremendous variability in terms of the scope of health IT and the types of EHI that will be exchanged and accessed. Accordingly, timely access and what constitutes without delay, according to ONC, will be a facts and circumstances analysis dictated by the type of record and the request. Within those same comments in the commentary to the final rule regarding what constitutes timely access, ONC referred to another part of the commentary where it addressed limiting or restricting the interoperability of EHI. And in that part of the commentary, ONC warns that, and this is a quote, slowing or delaying access, exchange, or use of EHI could be considered information blocking, end quote. And like its approach with what constitutes timely access, ONC indicates that unnecessary delays or response times that otherwise limit the timeliness of EHI may be considered information blocking, depending on the facts and circumstances. So in sum, what is timely and what is considered without delay will be a facts and circumstances analysis, and ONC has specifically avoided providing definitions to those terms. Healthcare providers and other actors, in thinking about what is timely access and what would constitute a delay, should keep in mind the final rule overall seeks to remove unnecessary impediments or obstacles to complete interoperability, including many of the protective measures that healthcare providers traditionally have taken on behalf of their patients. And ONC provides many clues regarding the types of delays it would consider as information blocking, such as delays that allow providers to maintain control over communications of test results but do not otherwise meet an applicable exception. So that's specifically addressed in the commentary to the final rule. So from this information, this commentary, and in the absence of a defined term, we can begin to understand the way that ONC would analyze what constitutes timely and what would be considered a delay, in particular as it relates to the release of test results.
So, Lindsey, if a healthcare provider wanted to delay the release of test results, what is the most likely exception that would apply?
As Gina discussed, healthcare providers often want to delay the release of test results to facilitate communication between the patient and the healthcare provider. The applicable exception in this case would be the preventing harm exception found at 45 CFR section 171-201. On this subject, ONC specifically stated in commentary that routinely time delaying the availability of broad classes of EHI will not fall under the preventing harm exception. Instead, any decision to delay the release of lab results unless required by federal or state law or unless caused by misidentified, mismatched, or corrupt data would need to be based on an individualized assessment of specific circumstances where a healthcare provider with a current or former clinician-patient relationship with the patient reasonably believes that the delay will substantially reduce a risk of harm cognizable under the preventing harm exception as determined on an individualized basis.
And Lindsey, can you reiterate the types of harm that the preventing harm exception recognizes?
Sure, Maggie. When a practice of information blocking is likely to, or in fact does interfere with the patient's access, exchange, or use of their own EHI, the practice must address a risk that the access, use, or exchange is reasonably likely to endanger the life or physical safety of the patient. That is a very high standard, and it is the same standard that currently applies under HIPAA's privacy rule regarding the individual's access to PHI, which is found at 45 CFR 164-524. When the practice either one, is likely to, or in fact does interfere with the patient or their legal representative's access to the patient's EHI, but the harm affects another person referenced in the patient's record, or two, if the practice is likely to, or in fact does interfere with a legal representative's access to the patient's EHI, the harm standard is lower in that the practice addresses a risk that the access, use, or exchange is reasonably likely to cause substantial harm either to the other person or to the patient as applicable. By the way, ONC stated that it would tie their preventing harm standards to the standards under HIPAA's privacy rule at 45 CFR 164-524, which is the individual's right of access, so that if HHS changes the standard under HIPAA's privacy rule, the preventing harm exception would not require an amendment and would automatically tie to the new standard.
Thank you, Lindsey. So how does this apply to the example that Gina mentioned, which is a healthcare provider seeking to delay release of test results due to a concern that the results will be upsetting or concerning to the patient, or the patient may misunderstand the results, so the physician will release after speaking or otherwise communicating with the patient?
Gina and I have been speaking with many healthcare providers on this subject, and we understand based on those discussions, as well as based on our experiences from our days as in-house counsel to large health systems, that healthcare providers generally have a list of labs that they categorically hold to allow the physician time to communicate directly with the patient. Even where the intent of a particular practice such as this that interferes with the access, exchange, or use of EHI is in the patient's best interest, such practice may be information blocking unless the practice is required by law or covered by the preventing harm exception or another applicable exception. On this point, ONC explicitly stated that it saw no evidence that a routine delay intended to foster the clinician-patient relationship would substantially reduce danger to life or physical safety of patients or other persons. A categorical delay of test results will not meet the preventing harm exception, which requires an individualized determination, and when the delay affects release to the patient, would require a finding that the release is reasonably likely to endanger the life or physical safety of the patient. As we stated previously, that is a very high standard and would generally not include emotional harm unless such emotional harm would rise to the level of endangering life or physical safety. Please note that ONC explicitly addressed commentators' request to broaden this exception to include psychological or emotional harm. In refusing to do so, ONC reiterated that the substantial harm standard currently used under HIPAA's privacy rule, which applies to a denial of a personal representative's access to a patient's PHI, would apply to certain circumstances of concern by commentators. ONC also reiterated that healthcare providers have significant and broad discretion in applying the preventing harm standards. Licensed healthcare professionals can rely on a wide array of individual patient characteristics and circumstances and apply all of the knowledge and skills within the licensed healthcare professional's scope of practice. This gives healthcare professionals broad discretion in how or why they form a reasonable belief that a risk of harm is associated with particular access, exchange, or use of their patient's EHI, including by the patient or the patient's legal representative. ONC has made it clear that nothing in the preventing harm exception would limit the types of information on which the licensed healthcare professional may rely or the factors they may consider in exercising their professional judgment to make individualized determinations of risk of harm consistent with the exception.
Gina, can you tell us about the other types of harm ONC recognizes under the preventing harm exception?
Yes, but before I do, one additional point on the analysis that Lindsey just provided that I think is important for our listeners to understand. Some states have state laws that address the release of test results, in particular sensitive tests like HIV is one example. The information blocking rule does not preempt those laws, so healthcare providers should be aware of any state laws that address this issue. And if they require a delay, if the state laws, that is, requires a delay, healthcare providers would follow those state law requirements, and that would not be considered information blocking. A note, what Lindsey and I have found in implementing and reviewing these state laws and advising clients on how to implement this exception, the laws can be tricky. So, for example, one state's law that we've looked at requires, quote, the opportunity, end quote, for a patient to speak with a healthcare provider about the patient's test results. The law doesn't state that the opportunity needs to come before or after the release of results to the patient. So there are some nuances that healthcare providers should be aware of in reading state laws and the information blocking rule side by side. And we would encourage healthcare providers to consult with counsel on those issues. Maggie, to your question regarding other types of harm under the preventing harm exception, there may be circumstances when clinicians or other users of health IT are presented with EHI that, due to a technical failure, is either entirely incorrect or contains inaccurate information. At other times, EHI may become corrupted. So this addresses situations that generally, due to a technical issue, you've got data that is just wrong or it's misidentified. Those situations also would fall under the preventing harm exception, but they would not require an individualized assessment. I think that's for obvious purposes. If you know that data is corrupt or if it's misidentified, misallocated to a patient, for example, you wouldn't do an individualized assessment of whether the harm standard is met. So in other words, if a healthcare provider is aware of incorrect, misidentified, or corrupt data, those circumstances would meet the type of risk standard under the preventing harm exception, and an assessment of whether such error would endanger the life or physicians, the life or physical safety, or cause substantial injury to the patient is not required. The practice of not releasing EHI should not be broader than is required by the circumstances, even in this type of situation with corrupt or misidentified or incorrect data. And ONC expects healthcare providers to take action to cure inaccurate or corrupt data and to not withhold those portions of the medical record that effectively can be shared without presenting the known inaccurate or corrupted data. In other words, known inaccuracies in some parts of the medical record would not justify withholding the entire record. The risk is limited to corruption and inaccuracies caused by performance and technical issues affecting health IT. For example, this exception would be relevant if only partial copies of results or inaccurate tests are linked to a patient's medical record. This risk would not extend to purported accuracy issues arising from the incompleteness of a patient's electronic health record, generally where, for example, additional test results or procedures would be added to the medical record. In those instances, ONC makes clear that the anticipated addition of other records or results does not render a record incomplete. Also, the preventing harm exception may apply to practices that are designed to promote data quality and integrity and support health IT applications, properly identifying and matching patient records, or EHI. When a clinician or other health IT user knows or reasonably suspects that specific EHI in a patient's record is or may be misattributed either within a local record or as received through an EHI exchange, it would be reasonable for such clinician or other health IT user to avoid sharing or even incorporating that EHI that they know or reasonably suspect would cause errors in the patient's records and thus pose a risk of harm to the patient. An actor's response to this risk, again, would need to be no broader than necessary to mitigate the risk arising from the potentially misidentified or misattributed data. And a health IT developer of certified health IT would not, for example, refuse to provide a batch export on the basis that the exported records may contain a misidentified record. Similarly, a healthcare provider that identified that a particular piece of information has been misattributed to a patient would not be excused from exchanging or providing access to all other EHI about the patient that had not been misattributed.
So to summarize, the preventing harm exception as it relates to a delay of test results, the standard for delaying access, use, or exchange of an individual's EHI is high and requires endangering the life or physical safety of the patient. That is more than emotional harm. ONC specifically addressed this issue and indicated generally, broad categories of test results that a healthcare provider seeks to delay will not meet the preventing harm exception and could be considered information blocking. Rather, healthcare providers will need to perform a case-by-case analysis of whether the preventing harm standard is met. Thank you, Lindsey and Gina, for producing this podcast. We know that there is a lot more helpful information that you will be sharing regarding the preventing harm exception, so listeners should be on the lookout for additional podcasts. If any of our listeners have comments on additional podcast topics, please let us know.
Thanks again for listening to Triage, rapid legal lessons for busy healthcare professionals. New episodes are available for download through iTunes, Google Play, and other podcast applications. By subscribing to Triage, you will receive timely notifications of each new episode. Also, if you have any topics that you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.